All right. Good afternoon. I am Alan Smith, President CEO of One Spartanburg Inc. I do want to take just a couple minutes, not even that long, really. I know we've got a few people on this call that probably don't have a lot of orientation to our organization, but we are South Carolina's only consolidated business economic tourism development organization. And we are delighted that you have joined us today, especially delighted that we have the speaker that we have, because I can tell you what he's going to talk about is incredibly important to what we're doing from an organizational standpoint, what we're doing as a county here, leading South Carolina really in economic development. I see that we've got David Britt on the call, who's chair of the Economic Development Committee on Spartanburg County Council, really a leader, a lead partner for us in terms of economic development. And let me just say, we are white hot when it comes to economic development in Spartanburg County right now. 791 million in new investment since January 1st of this year, 2,226 new jobs from January 1 through April 15th. If you break that down by day, that's more than $7 million in new investment per day, every day from January 1 through April 15th, and 20 new jobs created every day since January 1 through April 15th, every single day. So if you actually take that all the way back to January 1 of 2020, 1.2 billion in investment, 2,776 new jobs. But what's important for folks to remember on this call, the bill that we're going to talk about today could really undermine every single bit of that, take away one of our competitive advantages, so on and so forth. And I do not want to steal the Attorney General's thunder, so I'm going to let him have some thunder and drop the hammer too. I think that's important. But before we get into that, I got a few housekeeping things. Just want to make sure, like we do in every single Zoom call, to remind people to keep your audio muted. Please put questions in the chat box. This is a complex bill, and so there are no dumb questions. We encourage people to engage. We'll have a Q&A session at the end. Would not be here today if it wasn't for Wells Fargo. They're our gold sponsor. I see that we've got Ethan Burrows on the call with Wells Fargo. We appreciate their support, appreciate his leadership on our executive board as well. We've got our silver sponsor, Denny's. Always appreciate Denny's involvement and engagement in our work. And then, of course, Regenesis Healthcare, who really stood in the gap for some of the populations in this community that have been disproportionately impacted by COVID. Regenesis has done an incredible job responding to COVID-19, so we appreciate their support. And then, of course, from the very beginning of the Voice of Business Brunch, the Greenville-Spartanburg International Airport has been a presenting sponsor, and we are so delighted to have Tom with us today. When we came on this call, we were organizing. Tom said it's a great day to be in Spartanburg County, and so I'm glad he understands geography and the fact that more than 95% of GSP is in Spartanburg County. So Tom, deliver, if you would, a update and greetings from GSP.
Yeah, well, welcome, and thanks for everybody attending the Voice of Business. As Alan said, we're with the Voice of Business from the beginning and continue to want to support this program. We think it's really valuable to make sure that all the members and everyone in Spartanburg are updated with just all the great things that are going on in this region. I want to remind you just really quickly so we can go into the Attorney General's presentation, but it's never too early to start planning for summer travel. Every day is a little bit better with passenger traffic returning. And with that, airlines are also returning flights. Delta is going to be putting back their nonstop service to New York's LaGuardia Airport starting on June the 5th. And that will bring us to 21 nonstop routes available out of GSP. So as amazingly as that may sound, that's actually more than we had before the pandemic. So we're getting more seats and more frequencies back. Of course, Silver Airways is going to Orlando, Tampa, and Jacksonville. They just started up last month. So they have some low-cost service down to Florida if you want to get some sun and fun. And then we also want to remind, in the next month or so, you'll hear a lot of advertising out about new online parking that we will be putting out with a new website. Will allow people to buy parking in advance. So no more circling around looking for your favorite spot. You can go ahead and buy it in advance and have it. And so there'll be more information that coming, but stay tuned. But I do encourage, if you're looking at wanting to go travel, communities are opening up again, and flights are back, and there are still some very, very good fares out there. So hope to see you all at GSP, and have a great day.
Tom, as always, thank you. And, some of that economic development success I was sharing earlier has everything to do with our partnership with Greenville Spartanburg International Airport. It truly is an economic driver, not only for our county, our region, but our entire state. So we appreciate your partnership. As I mentioned before, we are delighted to have with us today the South Carolina Attorney General, Alan Wilson. And I've been in South Carolina now about a little over 10 years, Greer before I came to Spartanburg. And I've really appreciated the fact that we have an Attorney General, quite honestly, that stacked up against attorneys general throughout the country. He is probably one of the most pro-business, most pro-economic development attorney generals we have in the country. So we appreciate him being with us today. He is our state's chief prosecutor, chief securities officer, and the state's chief legal counsel. He's defended the Constitution and the laws of this state, even if it means challenging the federal government. And that's an important thing to say, because this is not state law. This is not state legislation. This is a federal bill. But a person that has Alan Wilson's stature has the ability to influence and impact federal legislation. And we appreciate him doing that. He has protected South Carolina's right to work laws, which you will hear more related to that. He's helped lead the 26th state challenge to the federal healthcare mandate, successfully safeguarded South Carolina's voter ID law, and fought to protect its immigration laws in court. And before he starts, I want to point out really what I believe to be the impetus of the PRO Act, and this is this. In 1975, one in four, 25% of the private sector belonged to a union. Today, that number is 6 in 100. So private sector union membership has fallen off a cliff. And regardless of what you hear, I believe, and there are a lot of people that believe, that the PRO Act really is all about just driving private sector union membership. Quite honestly, at the cost of employees, at the cost of economic development, and the cost of business. So we appreciate Attorney General Alan Wilson being here, and I'm going to turn it over to him.
Thank you, Alan. It's great to be with all of you today, and thank you so much for giving me this forum to talk about something that's very important to me. What I'd like to do is instead of starting with the PRO Act, I'd like to go up to about 50,000 feet and drill back down, because I think it's important for people to know kind of where I'm coming from as a public servant, as a public official, but also know the role of this office. So first off, for those of you who don't, I tell people this all the time. The Attorney General's office is probably the most important office, elected office, that people know nothing about. And I'm not so arrogant to think it's the most important office. It's the most important one that most people don't really know how it affects them in their daily lives. People can relate to their sheriff or their local prosecutors, their local House members, senators, congresspersons, whatever, governor even. But most people don't think about the Attorney General and the role that this office plays. And frankly, before I was elected, I knew what the Attorney General did generally, but until you get down into the minutia of the day-to-day things going on both in the state and around the country, it's just amazing the footprint this office has. And so I want to kind of educate folks. First, generally speaking, this office is about 300 staff, 90 of whom are attorneys. We'd probably be, if we were a private law firm, we would be the third largest law firm in the state. We handle anywhere between $100 million and $700 million in revenue or recoveries for the state on any given year. And I say 100 to 700, 800 million because it does, fluctuate based on, when cases come up and when settlements occur. Last summer, we negotiated the largest settlement in the state's history against the federal government. I am an equal opportunity offender. I have sued Republican and Democratic administrations, because my first role is to have fidelity to the state of South Carolina, regardless of who's in Washington, D.C. But it is, I've always believed that it is the role of the federal government to always want to self-perpetuate itself, to grow and get bigger. I've oftentimes referred to it as the blob, like that 1950s movie. It's just this nameless, faceless thing that rolls along and gets bigger and bigger and bigger and consumes and consumes and consumes, and it has no limiting principles. And it doesn't really matter which party is in power. It just, over the last several decades, the federal government has just grown and grown and grown. And so I believe my role as the Attorney General, as the state's chief legal officer, is to go into my bag of tricks or my bag of tools and to try to do what I can to constrain the government, not from doing good things, but from doing the things it has the authority to do and relegating everything else to either the courts or to local governments or to individual choices. So one last thing I want to say before I go into the PRO Act and my positions on unions is that oftentimes I get in trouble all the time with locals. We will issue an opinion at the request of a local legislator, and usually that legislator is doing it at the request of a local business owner or a trade association. Could be this one. And what we do is our opinions. You can't go to court and ask the court to give you an advisory opinion, but you can go to the Attorney General's office and ask for an advisory opinion of sorts that says, hey, we want to implement this law or this ordinance, or is this law or ordinance that is already in effect? Is it constitutional? Or I want to do X. Can I do X? And what we do is we look at the rules or the laws as they are currently written. We look at what other courts or courts in this jurisdiction have done in the past on this particular issue, and we give you what is our best guess on what we think a court would do. Obviously, our opinions are non-binding, which means legislators or individuals who request them through their legislators are free to disregard them. Courts usually cite to them when they agree with them, but courts are not bound to follow them. But they are generally given great weight in the General Assembly when drafting legislation, and courts when they are interpreting laws that have been passed by the legislature. So I tell people all the time, if you don't like something I've said in an opinion, it may or may not be my personal opinion. It is just my office's best guess on what will happen if you do what it is you want to do. Oftentimes, when we are requested an opinion, we'll ask the requester, which is the House member, senator, local government official, hey, do you want us to put this in writing? Because we've done the research. This is what we're going to say. Sometimes they're like, yes, we want that in writing. Sometimes they'll say, no, for heaven's sake, don't put that in writing. Sometimes they will want it, they won't agree with the opinion, but they will want it in writing because our opinions usually lay out a roadmap for how you can change policy or change the law or get to the result that you are looking for. So I just want to give that little disclaimer. Now, I'm also very transparent in when it comes to my views on things. I think I was early in my first term when we dealt with the Boeing case, which is when Boeing was trying to not transfer its operation, but expand its operation from Everett, Washington to North Charleston, South Carolina. And of course, the unions jumped in there, threatened to, they filed complaints with the National Labor Relations Board. They threatened to sue under Federal National Labor Relations Act. They did all these things only because a private business in a union state wanted to looked at the map of the United States, made a business decision, and wanted to expand its manufacturing operations of the Dreamliner down to Charleston, South Carolina. In fact, the company, Vought Aircraft, that Boeing was buying to expand its operations in North Charleston, the employees of that company that were unionized voted to decertify themselves from the union that was there at that time. And so that is important to note. And so I took a very public position that, along with Governor Haley and just about every other, and listen, Republican and Democrat, it was a very bipartisan coalition disagreeing with what the unions were trying to do with Boeing. And so we took very public positions. I think Boeing ended up negotiating a settlement with the union at that time. And of course, the unions, basically backed down. And of course, Boeing implemented its expansion project, which we have now in North Charleston. Fast forward to now, or in the previous 8 years leading up to this point, I'm taking a number of public positions, either in comment letters under the Administrative Procedures Act, or in public statements, or in letters to Congress on various things. Whether it, like the persuader rule is an example, is something that was a rule that was implemented by the Department of Labor under the Obama administration, which would basically kind of gut an employer's ability to have communications with consultants or attorneys without all of those communications being made public, because you're trying to persuade someone. Is even if the attorney that the manager or the employer is talking to is not communicating with employees, but simply providing legal consult. So we pushed back on that. We sent letters. We made comments to that rule, and eventually it was struck down. And when Mr. Trump was elected president, the Department of Labor under his administration rescinded their appeal, or they dropped the appeal of that. And so that rule went away. But that's going to come back under the PRO Act. Now, what is the PRO Act? I mean, for those, I'm sure most people on this on this Zoom meeting right here probably have already heard of it, but it stands for Protecting the Right to Organize Act. And it's amazing how they always give it a, rainbows and kittens and unicorns name, giving everyone a free dog act or something. It's always something that, looks very reaffirming and positive and protective of people's rights. But what it does is it seeks to erode people's rights, both at an individual level and at a corporate level. If you look at union policy, and I've studied this over the years, you go back to the Roosevelt, the New Deal era, the 1930s. Roosevelt pushed for and got passed the National Labor Relations Act, also known as the Wagner Act, which at that time, whether you agree or disagree with the National Labor Relations Act, which I disagree with on policy grounds, you can make a plausible argument that at that point in our history, there were a lot of laws, there were a lot of practices by employers at that time that could be viewed as discriminatory, maybe racially discriminatory or discriminatory based on someone's status, with someone with a disability, or maybe just discriminatory based on the power of the employer versus the perceived weakness of the employee at that time. And so maybe there was a view that we needed to give employees the ability to collectively bargain to protect their rights and protect themselves. And of course, the unions advocated for, and to their credit, they got pretty much almost everything they wanted. And over the last 70, 80 years, the National Labor Relations Act has been streamlined, namely the Taft-Hartley Act in the mid 40s, which gave the states the ability to create right to work laws. Currently, right now, there are 27 states in the United States of America that have implemented right to work laws. Now, I'm a right to work guy. I'm strongly a right to work guy. And the reason I'm a right to work guy is that I've always believed that if somebody has a product or a service that is of value to the community in which they seek to serve, then in the free market of ideas and services, that product should stand on its own. It doesn't need the government to compel people to buy it, else lose their job. And that's what these closed shops are doing. Is basically you go to states that are union states, in order for you to work on a manufacturing line or in a retail store or in any business that would fall under a union, you can only work there if you pay union dues to a union, whether you support that union or not. The freedom to associate embedded in our Constitution also has a converse interpretation, the freedom to disassociate. No one should be compelled to choose between feeding their family in a job or paying union dues. And for those who, when people have to choose between feeding their kids or paying a union dues, then they're going to always pay the union dues if they don't have options. We as a country have evolved a great deal over the last 80 years. And I think that with all of the protections, the constitutional decisions that have come down from the Supreme Court, the federal laws that have been passed, the state laws that have been passed, and the evolution of us as a society, unions no longer, if they ever did, but they certainly no longer exist to protect workers. Quite contrary to their narrative, they exist to self-perpetuate themselves, to grow their numbers. Alan, you might be able to correct me, but my understanding is private sector membership is in the single digits right now, and public sector unionship, I think, is probably in the low 30s compared to 20 or 30 years ago when you were in the 70s to 80%. I'm sure you probably have more correct information, but I believe that people, when they're given an open and free choice, free from coercion, free from molestation of any type, that they will choose to not pay union dues when they are happy in the company that they're working for. What the PRO Act seeks to do, and by the way, there is a difference between a law that is unconstitutional that I will fight and sue in court to have overturned, and then there is a difference between a law that is just horrible policy that Congress has a right to pass it. The PRO Act falls into the latter. Congress has a right to be Congress, which means to be bad, to be wrong on implementing policies that they want to promulgate. So I don't have. There is a few weeks ago I sent a letter with 22 states challenging the DC statehood law that's going through Congress right now. And I posed it on two grounds, policy and legal grounds. I said, I disagree with this on constitutional grounds, and I gave the constitutional and legal reasons why it's unconstitutional and why I will lead a 22 state coalition in suing to have it overturned in the Supreme Court if you pass it. But I said, even if it wasn't unconstitutional, it's bad policy. And I gave my reasons for why I believe it was bad policy. The PRO Act, unfortunately, only falls into one category. It's bad policy. They can pass it. So the letter that I led in this case was a 14-state coalition. There are other states that would have joined us, but for political reasons decided not to. So there's more synergy behind this letter than the number says. But 14 states joined this letter, and unlike the DC statehood that says it's bad law, it's bad policy, if you pass it, we'll sue you. Take that into consideration when you deliberate in Congress. The second letter on the PRO Act is, this is bad policy. We ask you not to pass it, and these are the reasons why. And then we go through the reasons. You can get a copy of this letter, and Alan, I'm happy to send it to you PDF so you can disseminate it amongst your members. It's a 2-page letter. This is it right here. 3 pages if you count the signature page. And it basically highlights the reasons we're against the PRO Act. The first thing about the PRO Act, I will say, that I just find absolutely abhorrent is it eliminates the ability of states, 27 states to be specific, who have, through its local elective legislations, or excuse me, through its local elected legislators, have chosen to be right to work states, meaning we don't want to compel workers into an association with a union that they don't want to be a member of in exchange to actually have a job. And it would gut that. It would basically eliminate the right, which is a right that people have had since 1947 under Taft-Hartley, to be a right to work state. It would do away with that. Gone. We are now all union states. Secondly, just to go through it, it would expand the definitions of what it means to be in a joint employer or to be an independent contractor. It would eliminate the persuader rule. It would, and what the persuader rule is, I think I talked about it a few minutes ago, is that, if you're communicating with your consultant, your PR people, or your attorney on labor issues and how you want to implement a certain policy as it relates to a union election and consult with them, assuming that we're no longer a right to work state, all of those communications could be subject to review by the union and the National Labor Relations Board under the PRO Act. You would lose that attorney-client confidentiality. You would lose the right. Currently, you have the right to permanently replace people who are on strike. If they're gone for a period of time, you can replace them with whenever you want. That would take your right away. The secondary boycotts, which were outlawed in the 40s under Taft-Hartley. In other words, if you are a neutral third party who is a vendor or a subcontractor to a party that is in the middle of a suit against the NLRB and collect the employees that are collectively bargaining with it, you're not even the one that's in the dispute. You're just a down the stream of commerce person. You can be boycotted now. You don't have that protection anymore under the PRO Act. It means they can go after anyone down the chain. So it's basically putting pressure on businesses who do business with businesses who are in a dispute with the union or its employees. It would take a lot of, here's another thing that I find incredibly abhorrent. I think when people want to vote on something, whether it's a vote that when you cast a ballot on election day for anybody, the dog catcher all the way up to the president, I believe people should be able to vote their conscience without having anyone over their shoulder. I believe that you should be able to say, this is what if you want a union, you should be able to vote for a union. If you want to be right to work or not be a member of the union, you shouldn't have to do it through a card check provision. The PRO Act would basically do away with private or secret ballot elections. It would make it so that everyone would know who you were voting for because you would do it through a card check provision. It would give the unions, it would mandate that employers turn over all its listserv of employees' contact information, their emails. It would prohibit employers from being able to have, now the union folks and the PRO Act people say mandated captive audience meetings where you force employees to come in and hear about why organizing would be bad. It would prevent you from being able to do that. They'd say we're protecting the employees from being a member of a captive audience. But if you're having an election you should have the right to present your employees, your workers, with how this could affect the bottom line of the business. I mean, that's what an election is about. It's competing ideas. They want to take that away from you. They want to take away the private ballot from you. They want to shorten the length of time it takes to conduct an election. They want the quickie election. I would think you would want an election long enough to get all the views on the table, to be as transparent as possible in the discussion of those views, and then let people vote on it secretly. They don't want that. They want to expand, like I said earlier, they want to expand the definitions of what an employee is and what a manager is to basically swell their numbers. If they can change the definition of an employee to be a larger group of people, to include managers and supervisors, that's just more people that have to pay dues to swell the ranks of the union numbers. Uber drivers, Lyft drivers, people who are independent contractors, they would love to get their hooks into those folks and to include them under that definition. Again, it's about numbers for them. The PRO Act would bring all of them up under that umbrella. Franchisors and franchisees, it would radically redefine those relationships, meaning that people you don't really have direct control over, you can now be held responsible for their violations of the PRO Act. Like a restaurateur who is a franchisee, or franchisor rather, it would pull all of them up under it and kind of loop them under that umbrella. It's a really, really very scary thing when you think about it. I'm going over a list in my head. I can look at the letter. I said expands the definition of a joint employee. It allows secondary boycotts. It gives the unions the right to use employers' private email addresses. I think I discussed that. Implements the ABC test, which again would increase the number of people who fall under as an independent contractor. Would include them. So I think of that scene in Forrest Gump where Forrest Gump says life is like a box of chocolates. This PRO Act, it's just it's like a box of chocolates. Instead of a diverse group of chocolate flavors, it's just a box you open up and we know what we're going to get. Unlike Forrest, we know what we're going to get. We're going to get a plethora, 20 to 30 bad union policies and laws that couldn't get passed individually. So they're throwing them into this super all-inclusive package that will radically revolutionize how employers and employees interact with one another on a national level. It takes out the 50-state laboratory test, and it eliminates the ability for states to tailor-make their policies and to grow their economies the way they want. And this is something that I am very concerned about. The current status, it has passed the House of Representatives. It passed, I believe, last month. I sent this letter in early April. It might have been in late March when it passed the House. It is now in the Senate. At last look, there are, Chuck Schumer has said that when this has 50 sponsors, he will give it a vote on the floor of the U.S. Senate. My understanding is there are currently 45 Democratic senators who are co-sponsoring. No Republicans have signed on in the Senate. I think the 5 states, I think you have the 2 senators from Arizona, Sinema and Kelly, have not signed on. Joe Manchin in West Virginia has not signed on. I think Warner in Virginia, and there's another senator, his name escapes me right now, but they have not signed on. Of course, even if they do sign on, they have to get rid of the filibuster, right? And as long as the filibuster is in place, then there's a way to beat this thing. Obviously, if 50 plus 1 senators want to blow up the filibuster, then it's basically everything is on the board. Right now, I don't see this law being passed based on the fact that they can't even get to 50 sponsors. And if they do, they can't get rid of the filibuster, which Manchin and I think one other senator said that they're against, and they would need 50 plus the vice president. So I feel guardedly optimistic. I with emphasis on guardedly, but it's like, again, it's past one side of Congress. It's over in the Senate, and they're just a couple of votes away. So it's a real threat. And I see some questions popping up, and I'll let Alan pitch those to me in just a second. I'll close with this, and then we can go to Q&A. I have a very simple philosophy about government, or anything that comes out of government, whether it's an executive order, a rule, a policy, a process, a law. Good government has 5 attributes. and I say this in almost every speech I give because I think it's really important. Government should be responsible, predictable, accountable, profitable, and stable. I'll repeat that: responsible, predictable, accountable, profitable, and stable. The last two prongs of that 5-prong test that I just told you is, profitability and stability. I really don't think those are components of government. I think those are byproducts when government gets out of the way. Profitability and stability in the free market, the ability for people to grow their business, to create more jobs, to provide more jobs to more people, to continue to grow the business, to provide the goods and services that they were designed to do. A couple of weeks ago, our president said that unions built this country. With all due respect to the president, I disagree with that. People built this country, people who took a risk, people who assumed risk, took on debt, put their name out there, came up with an idea, a good, a service, a product. And they felt that the free market, and a lot of people fail in this process, but they had the courage to go out there and put their name on the line and to provide a good or service and create those jobs, to provide those goods and services and products. They're the ones who built this country. Unions are basically like those little lympher fish that live in the jowls of great white sharks and clean the teeth of sharks. They don't produce anything, they don't do anything, they don't provide anything. They just kind of latch on to bigger fish that swim around the ocean, and they live off of whatever meat is left in the teeth of those sharks. I mean, that's probably a bit graphic, and Alan told me not to hold back, y'all. He told me to get graphic and pummel the folks, but I'm just not a fan of unions. I've got friends who are in unions. I have friends who are pro unions. I don't demonize individual people, but I do demonize ideas. And this is a bad idea. And it fails the 5-way test that I just talked about. It doesn't create a responsibility in government. There is no predictability in the free market. There's no accountability with this, and it will undermine profitability and stability in the free market for all of you. And as your Attorney General, I will continue to be a voice against this. I will scream as loud as I can. When a law is unconstitutional, I will sue on it. And when a law is just bad policy, I will yell about it. So that's where we are. Alan, I'll turn it back over to you for any potential questions or thoughts.
Well, Mr. Attorney General, we certainly appreciate that overview and appreciate your opposition to this bill. I think it's important for our viewers to know too that our Congressman William Timmons cast a vote against this. U.S. Senators Graham and Scott have come out very publicly against this as well. So, we've been asked, well, why are you, devoting so much time, energy, and resources, talking about the PRO Act when most of the South Carolina congressional delegation is against it? Well, we think that it's something that people need to know about. That's something that our folks, especially the way our employment community is structured, they need to understand what this bill is and what this bill isn't, so they can get vocal in their opposition to it. In fact of the matter is, the tentacles of businesses that are based in Spartanburg County go to some of those states that the Attorney General mentioned that have senators that are trying to make up their mind. And so we need to make sure that they're influenced as well. So I just want to point out that, our congressional delegation is exactly where they need to be on this piece of legislation.
Alan, can I interject something real quick?
Yes, sir.
You got my mind thinking. We sent this letter 6 weeks ago, or almost 6 weeks ago. I read an article yesterday or day before yesterday in which Joe Manchin said he had concerns about the constitutionality of a number of things, and he had grave concerns about a number of issues, DC statehood being one of them, and the PRO Act. And one of the things that he said is that the number of lawsuits that he thought would come out of the states fighting the PRO Act and DC statehood, or at least components of the PRO Act. I don't think everything in the PRO Act is unconstitutional, but certainly, the implement, and there's a question in the box here that says, can it be done through executive order? I am going to challenge as unlawful anything that the president does through executive fiat that doesn't go through the Administrative Procedures Act, or doesn't that goes outside the authority of what an executive agency has the authority to do by federal law. In other words, we're going to push back on every technical law out there, so that if someone's trying to pass, if the president tries to do an EO to effectuate these policies without passing them through the people's elected representatives, we will sue. Maybe not, again, Congress can vote to do this, but there's a lot of things in this bill that they can't eliminate right to work through executive order, for instance. So, I mean, those 27, if this law doesn't get passed, he can't take away the 27 states' right to work laws through executive fiat. But if he does, or if he tries to remove some of those other protections that are under the Taft-Hartley Act, we will fight those on lawful and rule of law grounds.
Very good. I mean, so it does matter if we're in South Carolina. I think the other thing too is, with a little less than a 3% union penetration rate in our state, that means that 97% is free game. So this would be a target-rich environment if you were a union and you were able to operate freely in South Carolina should the PRO Act pass and our right to work laws go away. So I think that's important. And we know that this is a target-rich environment already because they've targeted Boeing, as was mentioned earlier. They see South Carolina as a real opportunity. So I think it's important to point out that, yes, this is germane to South Carolina. It's something that we should be concerned about. So yes, one of the questions was, what are some of the components of the bill that could get passed or maybe implemented through executive order? And I think that question is timely as well, because I just got an update a couple hours ago from the Wall Street Journal that says the current administration blocks Trump era gig worker rule. So one of the components of the PRO Act is the 40 million people that are 1099s or contracted folks. That status could be in jeopardy because the PRO Act would really make it difficult for them to be classified 1099. They would have to be employees, which would mean if they were employees, they would then could be coerced to join the union. So that's 40 million potential new union members. And so you already have an example of the executive branch looking to implement some of the components of the PRO Act. Attorney General, you want to weigh in on that?
No, that's absolutely right. And I read the same thing. Also, the persuader rule, I talked about it in my remarks earlier. That was actually a Department of Labor rule under the Obama administration, which I joined in a lawsuit with the state of Texas on that in the district court in Texas, and it got stayed rather. And of course, while the federal government was appealing that the court's injunction of that rule, that was when former President Trump was elected. And of course, the Trump administration, their Justice Department abandoned defense of that, and the rule went away. I would expect to see that come back through executive fiat, or at least through rulemaking. But again, we won on that one before, at least at the district level, before it was abandoned by the Trump administration. So, I think you could see a handful of these things be attempted through rules or executive orders. Those two being the two that jump to mind.
Thank you. Any other questions or comments? Okay, well, Attorney General Wilson, we really, really appreciate your time today. Appreciate your advocacy as well. I mean, this is critically important. I think it's easy sometimes too for us to maybe get excited about the things that we're against, but there's so many things to be for in South Carolina, and this could put a lot of those things in jeopardy in terms of growth, in terms of economic development, in terms of being a destination for business. We are that in South Carolina, and we want to protect that. We want to make sure that momentum continues. So again, we appreciate your advocacy in protecting that momentum that we have here in South Carolina. I want to thank again our presenting sponsor, Greenville Spartanburg International Airport. I want to thank Wells Fargo, Denny's, and Regenesis Healthcare. The Voice of Business is something that we do often. We called it the Voice of Business Brunch in the past, and I very much look forward to where we can be together and have brunch together again and talk about important legislative affairs issues. So again, thank you for
Alan,
watching. Yes, sir.
I'm sorry, 20 seconds.
Yeah.
I don't know how many people will be watching this broadcast when y'all put it out, or how many are watching it now, but I want to make it abundantly clear that either through this association, through your group, or through individual companies, if there's an issue out there that you think is either bad policy or unconstitutional or violative of law or your rights, please let us know, either through your elected representative or through this organization. You have my contact information. My number one goal is to keep the government out of your hair so that you guys can do what y'all do best. And so if don't assume that we know what's going on in your respective industry. If you let us know, we will. Our bully pulpit is your bully pulpit. This is your office, not mine. I'm just the trustee of it. So please let us know how we can serve and help each of you in your individual capacities. Thank you again for letting me say that.
Absolutely. Great point. And if you can contact, our organization, contact me directly, asmith@onespartanburginc.com, and we will get you in touch with Attorney General Wilson's office. So again, thank you all for watching. Thank you for your engagement. Thank you for your willingness to learn about this important piece of legislation. So until next time, we'll be signing off. Thank you.